We don't know what's going to come out of that, but if you're going to be informed about the issues, I actually have an article from a legal newspaper from last week, and there are probably 7 different bills pending in the state legislature for various reforms to be brought to the grand jury proceedings, ranging from one which says all grand jury minutes should be released in every case, whether there's an indictment or no indictment, all the way over to Governor Cuomo's proposal of a report only in cases involving police officer, civilian encounters, and only in cases in which the grand jury votes not to indict. So there's a whole range, a whole gamut of proposals. We don't know what's going to come out of it, if anything. It's a pretty safe bet, though, that grand juries are here to stay in New York. They are guaranteed by the New York State Constitution. It would require a constitutional amendment to do away with them. However, this idea about grand jury secrecy, that is not guaranteed by the Constitution. That is just set up by statute, by a law that could be amended by the legislature. So a lot of the proposals are not talking about abolishing the grand jury. They're talking about dealing with aspects of this secrecy and how much is the right amount or how much is too much. So I will leave it at that, and then we'll entertain your questions. I see some nodding heads. I think I'm going to probably get a couple.
Thank you both. I think you'll agree we have 2 very knowledgeable panelists. Now for the question and answer period, what we'd like to do is take one person at a time. Please, questions rather than any personal or political statements. And please be respectful. Allow anyone else to speak before you do. And one question per person at a time, unless we have more. So who wants to go first? Well, we have one.
Am I correct in hearing that the only thing the Constitution requires is a grand jury, and all the law that goes under it is subject to change? Or are there more constitutional things that are sitting there that we can't change?
The New York State Constitution reads as follows on this point. Article 1, Section 8. No person shall be held to answer for a capital or otherwise infamous crime unless on indictment of a grand jury. So the constitutional guarantee is you can't be brought to trial. They say infamous crime, that's interpreted to mean felony. You can't be brought to trial on a felony in New York State without a grand jury having heard the case and deciding that there's a sufficient amount of evidence for an indictment. That's what's guaranteed by the Constitution. The rest of the mechanics that we've talked about are pretty much all contained in the criminal procedure law, which is a statute passed by the legislature.
Thank you.
Either Roger or Mr. Lee could speak on this. Could you speak on the fact that correct me if I'm wrong, but it was the DA in the Ferguson case, that in actuality he probably should have recused himself because he had a family member that was in the police force that was killed at the time, and why he did not recuse himself to take on that case and have someone else defend the case, and prosecute the case? Excuse me.
Could you repeat the question?
The question was whether or not the district attorney in Ferguson should have recused himself because of a familial relationship with perhaps the police department in a similar situation. I'm not really familiar with that, but I can speak to the recusal issue. And we as and myself, I do it often. If I feel that I have a relationship with a defendant or an individual charged, or if there's an appearance of impropriety, the law provides for recusal, and it would be passing it on to a district attorney in another county, or perhaps the Attorney General's office. And in this case, with the special monitor as proposed by the governor, it would be, if the case were decided, if it were decided that it should be represented, it would be presented to a special prosecutor, probably someone as Attorney General, to prevent the appearance of any impropriety going forward.
No, thank you. Either one of you, I think, can answer this. I think particularly Senator Early. I want to talk about the selection process of the grand jurors themselves. If I was selected, and I know you said that there's two grand jurors, there's one of them that spends like 4 weeks, the other one spends three days a week. Say for instance there was a case that was going on that, or something just happened. Do they take the jury that is currently being used, or do they come with a new jury? Or say for instance, this thing happens and I know all about the information because of social media. I've seen the faces, I've read the newspaper and all of that. How do they select the jurors for grand jury? And are they really peers, or supposedly peers of the person being accused? Are they selected from the same city? Are they outside of from the suburbs or whatever? I just want to know if I'm a African American male and if there's a person being accused of something, are their peers actually going to be from that area or from outside that area? There might be two questions.
I got it.
Okay.
So for example, so you're chosen for grand jury, you get that grand jury number one, that 5 day a week for 4 weeks, you sit there. So all of the cases that we need to present during that time frame would go in front of you as the grand juror. So you don't know what you're going to get. You are given an instruction, I know, by the Part 1 judge who would impanel you at the beginning, and you would also be given an instruction by the DA, the prosecutor, when they begin, that you are to disregard anything that you hear in the media, on social media, and on television, and that you basically have to promise that you could base your decision solely on what you hear in the grand jury room. Grand jurors are selected the same way the trial jurors are, but I can tell you in my experience, this is year 24, I believe that the grand juries are becoming more and more diverse and representative of this entire community, city, suburbs, everything, and I'm very pleased with that. Does that answer your question?
It seems like, what is your opinion on the governor's proposal to have just those ones that involve a system, like involving the police, having a more open grand jury? What's your opinion on that proposal that he's presenting?
My opinion?
Both yours.
Reverend Hargrave indicated that he wanted to have a calm, respectful, civil discussion, and yet he invites two lawyers here. Go figure that. I'm not a big fan of the governor's proposal as it currently stands, because basically everything is still invested in the individual prosecutor. And the same concerns about the strong working relationship between prosecutors and police will exist. And if the monitor's decision whether or not to appoint a special prosecutor is dependent on this report, and the report is written by the prosecutor, it just doesn't seem to pass the smell test to me. That's my view of it. I prefer Judge Lippman's proposal, put a judge right into the grand jury room, let him hear the testimony, and let him decide what charges should be considered by the grand jury. No lawyer likes to cede any control that they have, and prosecutors very jealously guard the power that they have. They would like to be able to make the decision about what charges should be considered by the grand jury, and I understand it's very difficult for them to voluntarily say, okay, we'll give that up. I'm not a prosecutor, so I don't have that mind frame. I think that the system would work better, and I indicated this afternoon as well. One of the things that lawyers do after a case has been indicted, the defense attorney is going to make a motion and ask the judge in the trial case to look at the grand jury minutes and decide, is the evidence that was presented at this grand jury sufficient to support the charges that the grand jury actually brought in the indictment? And it's not unheard of, and Judge Pompiano is nodding his head, it's not unheard of for the judge to read the minutes and say, no, this charge was not made out, this lesser charge was, but not this higher charge. Well, having a judge in the grand jury room in the first instance and deciding which charges the grand jury should consider would greatly cut down on instances in which a reviewing judge is going to have to decide these issues or find that the grand jury evidence was not sufficient to support the charge. That's why my preference is Judge Lippman's bill. Obviously, the District Attorney's Association is endorsing and embracing Governor Cuomo's bill.
And just to add there really is a check and balance, as Mr. Brazil said, when indictments are handed out or cases are billed, and last year we had over 1,400 of them, judges such as Judge Pompiano would review the minutes to make sure that the evidence was legally sufficient, that the appropriate law was given. So there's a check and balance on that, on those cases that are billed and raised to indictment. With the governor's proposal with the special monitor, again, that would be a check and balance on the no bills to make sure that we were doing our job. So we have the check and balance on the bills, that being the court, and on the no bills, it would be the special monitor. So it gives balance, I believe.
Since we do have an expert witness, Judge Pompiano would like to.
Overruled. You can't say that to a man of God.
Higher authority.
Actually, there is. I'm going to be brief. First of all, I'm just so impressed. This is wonderful. Sandra and Roger would come out here and share this information is something that just hasn't gone on before now, right? I'm going to add a couple quick things, and I'll turn it back to you. What a lot of people don't understand is that the grand jury is an arm of the court. It's not an arm of the prosecutor. There's been a lot of misinformation about that. And one of the great things about the grand jury system that we have now under Article 190, and this gentleman mentioned, you start to get close to the issue. Is it just because the prosecutor puts evidence in, calls witnesses, gets an indictment? There's a full review and challenge to the legal sufficiency of that indictment. And they were talking about the responsibility of the judge who gets the matter in Superior Court to review those grand jury minutes for their conformity with the law, that they're legally sufficient under Article 190, that they're not defective, that the number of grand jurors who were supposed to be in the room were in there, what was instructed to them, who came before them. And so this isn't just willy-nilly the prosecutor goes out and gets an indictment. Defense counsel have a right to ask me to review that indictment for its legal sufficiency. And that's huge, because county court judges and Supreme Court judges who handle the criminal part are elected officials who are accountable to the public for the work we do. And I know in the last 5 years I've written over 700 grand jury decisions. 700. None of them reversed on appeal. And I like to think it's because we really do our work. We read everything, we review it, we try to be fair, we issue a written decision. So, I'm just going to say quickly that I am a fan of the grand jury system. I'm a fan of the privacy, of the security that it provides, particularly in this very violent age of things going on. We talked about redacting names out of the grand jury. I was sitting on my porch and I looked over next door and the shooter shot the guy. So what if the name's not there? Do you know who it is? Right? I mean, let's be honest here. The grand jury system is in so many states, and you heard Roger talk about 23 states that don't have it. So what happens in those states? The top cop gets to charge you or not. That sounds more political to me than a district attorney's office presenting evidence and witnesses and testimony. And then, number two, having the judge review it for its legal sufficiency when it's challenged. So, if you ask me which road I'd like to go down, Roger, Sandra, I would like to see the system remain in place. I think it's ridiculous to have judges in the grand jury. Grand jurors need to do their work, let things be presented. We get a chance to read and review every single word that's said in that room, review what people came in, review how it was handled, review what law was given, and determine whether or not the process was fair. Many times I've thrown indictments out, I've modified them, reduced charges, or let charges stand. And I think that's really very critical and very helpful. Robert, thank you.
One question you didn't address, is there ever a situation where an indictment is not presented, you felt that charges should have been done?
I never get it then. Because we only get matters after they're indicted, or if an individual consents to be prosecuted without an indictment, then it comes to us. So we don't play a role in deciding what charges should be brought. That's law enforcement in conference with the district attorney's office. We're like the next level, where we review what they did to make sure it was just, fair, and complies with the law. Thank you.
Thank you.
I'm in jail. I've been arrested for a felony. And how long do I stay in jail before anything happens? And tell me what happens before I get to the grand jury. And then after the grand jury, how long does it take for the next process? I've reviewed, I don't have bail money.
Gotta get the microphone.
Just wanted to make sure I said it.
You know that two-word answer, it depends? Basically, in New York, if a person is arrested and charged with a felony, there's something called a felony complaint that's filed. The law says that within a 144 hours, which is 6 days, of when they are arrested, they have to be given what's called a probable cause hearing or a felony hearing to determine whether or not there's probable cause to continue to hold them in custody, not to decide whether the prosecution goes forward, but whether they should be held in custody. But there's a big sort of caveat to that, and that is if the grand jury indicts the case before the expiration of that 144 hours, there's not going to be any preliminary hearing, and the individual will remain in custody. So the first it depends is whether the case goes to a preliminary hearing or whether the grand jury indicts it within that 6-day period. And it's the usual practice, certainly for what are considered violent felony offenses, category of crimes in New York, that the Monroe County District Attorney's Office tries to indict the cases within the 144-hour period. They'll come into court on the date of the preliminary hearing with a piece of paper called a certification saying the grand jury has heard evidence in this case and they have voted an indictment. And as soon as that paper is filed, the local criminal court no longer has jurisdiction. Now the case is going to be transferred to county court where Judge Piampiano sits. There's usually a delay between when that, there's a whole lot of terms that nobody quite understands where they came from. When the grand jury votes a case, they'll bring in the certification saying the grand jury voted to indict this person. But the grand jury decision isn't announced until there's a grand jury rising. And then after there is and that rising can take anywhere from a couple of days to a couple of weeks after the vote. It has to, the rising will come in during a 4-week period that the grand jury is sitting. But if your grand jury sat in the first week, and they could file a certification, it's not necessary that the case rise until the 2nd, 3rd, or 4th week. So you could be sitting for that period of time as well.
And not know that something's happened.
Well, you know
Sitting
that
in
you've been
jail.
indicted because you've come to the preliminary hearing and the district attorney has filed that certification and you know you've been indicted. But you don't know what the charge is and you don't know when you're going to be going to court until the grand jury rising occurs, and then it's calendared in either county or Supreme Court, and you appear for the first time in front of that judge in county or Supreme Court, make another bail application at that time. If the judge doesn't release you, you're going to be held in custody, and then the real periods start to stretch out, and it really depends on how the case goes. But you have pretrial motions that have to be filed. Very often the motions require that there be some type of a pretrial hearing, which has to be scheduled, and then the matter has to be set down for trial. And the goal of the Office of Court Administration, Judge Pompiano, what is standard and goals for a felony indictment?
180 days, 6 months
180
from the
days.
date of filing of the indictment.
From the date, okay. So you add on whatever time you were in before it appeared in front of the judge, or when the indictment was actually filed. The goal from the Office of Court Administration is to bring the case to trial within 6 months. They also keep track of cases that are beyond standards and goals, and there are a number of them. Things happen during this period of time that cause delays. Sometimes a trial is scheduled and has to be the scheduling has to be changed for various reasons. So you can be sitting for a good long period of time, and the more serious the charge, I mean, I'm not trying to tell ghost stories here, but for persons who are charged with murder, it's not out of the realm of possibility that you could be sitting 6, 8, 9 months before, or more, before the case actually comes to trial.
Just one last question. When do you see your attorney if you qualify for a free attorney?
Okay. Every person that is admitted into the jail, new admissions every day, the Public Defender's Office gets a list of all new admissions. And, well, let me backtrack. Okay. I'm actually talking about the old system. Let's move into what the new system is going to be. There are 27, some ungodly number, of different courts in Monroe County. Every town has its own village or town court, and many of them have several different judges. So when you add them all together, there's a lot of different courts. If you're arrested for a felony charge in the town of Clarkson, you may be arraigned in front of a town justice from that court, and depending on what hour of the day you're arraigned, you may have a lawyer or you may not. Currently, the Public Defender's Office only covers arraignments in the town courts from 8 a.m. to 8 p.m. Starting on June 1st, we're going to be going 24 hours around the clock. And there are literally going to be lawyers sitting by the telephone, like the Maytag repairman, waiting for a phone call to come to Sweden Town Court or Irondequoit or whatever to handle that arraignment. So that would be your first meeting with an attorney. But believe me, it's not any substantive meeting because it's a very short shrift. After the arraignment, the case comes back to the office. I actually am the person that's responsible for assigning felony charges within the felony cases within the public defender's office. And based on what the charge is, how serious the charge is, in New York there are what are called non-violent felony offenses and violent felony offenses. And violent felony offenses are the more serious, they carry the more severe punishments. So those cases get assigned to the most senior attorneys, the most experienced attorneys. The non-violent felony offenses are assigned to experienced attorneys. When I say experienced, they've been in the office usually about 5 or 7 years before they get into non-violent felonies, 5 years at least. Misdemeanor cases are assigned, they're the least serious, those are assigned to the least experienced attorneys in the various town courts and in Rochester City Court. So now, after the case is assigned to the attorney who's actually going to handle it, they're going to come and see the person because this 144 hours that I talked about before, they've got to run out and talk to the client at the jail before that preliminary hearing is scheduled so they know what the case is about, what the client's position is, whether there are any witnesses that the client thinks may be helpful to see if they can be called at the preliminary hearing. So that's the first substantive meeting. It's usually within about 2-3 days of when you're first arrested. Does that answer?
Okay, this is a question. Judge Fabian was saying that he doesn't see any kind of non-bills. Okay, what happens if there is a judge? Personally, I think there should be a judge in the grand jury. Sandra, do you see a judge, if you're questioning a witness, do you see a judge then possibly asking a question, a follow-up question, or is he just sitting there to make it like a legitimate, you want to add certain legitimacy to a grand jury procedure now by adding a judge. Do you see a judge then asking a question? And secondly, if they come back with a non-bill, then can the judge say, no, I don't think it's right? There should be a bill brought, to the Superior Court?
The proposal by Judge Littman would allow the judge, who would be then sitting in the grand jury, to ask questions as well. But I believe the proposal, as given in the state of the courts, would ultimately still leave the vote up to the grand jury. The judge, in Judge Littman's proposal, would be there to ask questions or supplement the questioning of the prosecutor, perhaps give influence on what charges should be presented, but ultimately the vote would be up to the grand jury. And it's a majority vote. It's not unanimous like a trial jury. It's just more than not have to vote to bill. So I understand what you're saying. In your view, it would add more legitimacy, but again, the check and balance is for the bills, meaning the indictments, our check and balance is the judge who reviews the minutes. For the check and balance for the no bill would be the proposal of the governor being the special monitor, who would not only review the grand jury minutes, they would actually be also reviewing the police package, all of the reports generated in connection with the investigation to make sure that we were calling the right witnesses and advising on the right law. So I see with the special monitor the check and balance there, with the no bills, and again with the bills, we see the check and balance with the courts. Does that make sense?
Thank you.
Since it's often stated that there's a very cozy relationship between the prosecutor and the policeman, especially in smaller towns, and then it's been stated that there could be a special prosecutor called in. Why don't they do that every time there's a policeman involved with a civilian, rather than maybe having to do it twice with a prosecutor and then a monitor? I heard some of that discussion the afternoon on the video, so I'm still a little confused on that.
You want it? Yeah.
You can go first, Roger.
You listened this afternoon and you came to see me?
You must have loved us.
Yes. I'm not sure at what point I said it, but I think I said that that Governor Cuomo's proposal for grand jury reform has sort of changed over time. His original proposal was to have a special prosecutor appointed in every police civilian homicide case for purposes of grand jury presentment. And then it kind of switched to, rather than having a special prosecutor, have the Attorney General's office, someone from the Attorney General's office, which is still an arm of law enforcement, but much less, doesn't work as frequently or closely with local law enforcement as the district attorneys do. And the New York State Attorney General Schneiderman basically has been pushing that proposal that an assistant attorney general handle the prosecution. Assistant attorney generals do handle some prosecutions in the regular course of business. They do some drug prosecutions. They do a lot of Medicaid fraud cases and cases involving elder abuse. So there is precedent for the Attorney General's office, which is generally a civil office. There is precedent for them to do prosecutions. But as I said before, nobody likes to sort of voluntarily give up authority, and the District Attorneys Association doesn't want the Attorney General's office to step in and become the prosecutor in these kinds of cases. And you can decide for yourself what the pros and cons of that are. And one of the questions is, where do you draw the line? And what cases are going to be preserved or reserved for the Attorney General prosecuting? Which ones can, is it, if the person is assaulted but doesn't die, does that become a local prosecutor case, or does that become an Attorney General case? So I think there isn't a lot of political traction for the, currently, for the idea that there would be a special prosecutor appointed in every police civilian encounter that results in either a homicide or a serious assault.
If I could just add briefly, yes, prosecutors work very closely with law enforcement. The cases, the police officers make the arrest, and it's a